it was on that basis that they did not call witnesses that were relevant to proving that the extradition was unlawful. And then the case of Schultz was presented as authority for that point. And so they called two witnesses to prove their case in what S versus Lamini and the other cases state should be beyond reasonable doubt. Now, every single point that we make in our heads of argument, my lord, are bits of evidence, oral testimony and documentary evidence that the state either provided us by handing it up as an exhibit or that the state's witnesses confirmed. And so I'd like to put to bed this point that the state raises that Ms. Cholota ought to have been called as a witness, and because she wasn't, that is fatal to her case. All of these four issues are proven by the testimony of the state's own witnesses. There was no reason to call Ms. Cholota because the factual evidence or the material facts that were necessary to prove this were already proven to us or were already confirmed to us, and we will go to the instances where they do that, by the state's own witnesses. Now, my lord will notice in the state's heads of argument, there isn't a single mention of Captain Carlett's evidence, nor is there any mention or discussion of Brigadier or Major General Gerber's evidence. Now, this is quite peculiar because one would think that if the state has called witnesses and those witnesses have given testimony, that those points of their testimony that were relevant to proving the state's case would be set out succinctly and summarized. But nothing is done in that way, my lord. Instead, what the heads of argument do, the state's heads of argument, is take point by point our case and attempt to disprove that, but from the perspective of the prosecutors, not from what the witnesses themselves told this court. An example of this, and we'll elaborate further, is the admission in the Constitutional Court affidavit by Captain Carlett that Ms. Cholota was charged because she would not implicate Ace Magashule. He confirmed under oath that that was his affidavit. He then confirmed that he was the Benjamin Friedemann Carlitz that is noted in that affidavit, and he confirmed in the trial within a trial that was what he stated in that affidavit. But the state's heads of argument tell us that no, that cannot be true because that's not why Ms. Cholota was charged. My lord, the state cannot call into question the evidence that was presented by its own witnesses without having to call those witnesses either unreliable or untruthful, because both things cannot be true at the same time. It cannot be that Captain Carlett, under oath before us in the trial within a trial, admitted that that was his affidavit, admitted that that was what was stated in his affidavit, and admitted that he was signatory to that affidavit. But then the prosecutors come and then they tell us, no, that's not true. If the prosecution in this case wishes to be witnesses in this case, then the door is open for them to sit in the witness box and give testimony. But what is impermissible, my lord, is for the prosecution to try and disprove or explain away the testimony of their own witnesses that we all sat in this court and heard. Now, it then goes further. Major General Gerber, in his testimony, is asked under cross-examination, Major General, would Ms. Cholota be an accused in this case had she indeed implicated Mr. Ace Magashule? And he responds, no. He responds she would not. That if she had implicated Mr. Magashule, she would not be an accused in this matter. That is their own witness under oath before a court of law. And so, despite what the heads of argument and oral or written submissions of the state may say, what this court needs to take into consideration, and take into consideration only, is the evidence of the witnesses of the state, not the explanatory notes and evidence from the bar that the prosecution has included in their heads of argument. A second point is the fact of Ms. Cholota was a fugitive. It was put to both witnesses. Who told the US authorities that this was a fugitive that needed to be extradited? Both witnesses were clear. One said it was the Office of Advocate Deniertion. The other said it was Advocate Deniertion. That is what the witnesses said. And that they were not the ones to tell the US that Ms. Cholota was a fugitive. And they gave this evidence when they were pressed to. Because at no point in any of the many affidavits that had been submitted in courts up until that point was it clear who it was that alleged that Ms. Cholota was a fugitive and on what basis that was said. And this is clear, my lord, from the reasoning of the Honorable Magistrate Dalanga in the bail hearing, when all she was looking at was whether or not to deny bail on the basis that Ms. Cholota might flee. And the submission that had been made by the court there was that, well, because she's a fugitive from justice, then there's a big possibility that she would flee and that she would evade justice. But when that point was pressed, that on what basis was she a fugitive, there was no evidence, leading to the Honorable Magistrate recording in her judgment that I could find no evidence that this person was a fugitive from justice. And she went further. She did not have to, but she went further to clarify, to say all I could see was that at all times Ms. Cholota was at her university and attending her lectures, and that the communication that the state had pointed to, that the US Marshal at some point wanted her, was for arrest purposes, because she had changed addresses, not because she was on the run. And so if we just take that point, my lord, if we say, indeed, there is no proof that this accused was in fact a fugitive, then the entire extradition argument falls apart, because it means that they extradited someone or led the US to extradite someone that was never a fugitive to begin with. That is central to this case, my lord, and that is something that the state ought to have brought witness after witness after witness to show in what way Ms. Cholota was a fugitive from justice. They admitted, both witnesses, that they did not contact Ms. Cholota after that date. We tried to ask, show us correspondence, take us through, take us to anything in the papers that would show that you said, Ms. Cholota, Moroadi Cholota, come back to South Africa, your trial is in May. They could not. We tried to ask them, then show us communication from her, where she states that, under no circumstances am I ever coming back to South Africa. I will stay in the US and I will not stand trial. But we showed on the papers that when Ms. Cholota was called by the Zondo Commission, when she was in the USA, not only did she attend the commission, she did so by paying for her own flights. She booked her own flights back to South Africa. She went before the Zondo Commission. She testified before the Zondo Commission. And both witnesses, for all intents and purposes, did not dispute that she appeared before the Zondo Commission while she was a student in the United States. That was never in dispute. And so the only evidence that is before this court was that when Ms. Cholota was contacted and requested to come into the country, she took it upon herself to come into the country. That was Captain Carlitz's evidence. That was why, when they contacted her, they did so on the basis of that testimony and said, we saw your testimony at the Zondo Commission, and we'd like to have further questions with you regarding that testimony. And so that's also something that the state cannot now come and dispute and say, well, we have no proof that in fact that was the case, when there is nothing, my lord. In all the 22 volumes of evidence we have in this trial within a trial, where Ms. Cholota is seen to communicate that she has no intention of returning back to the country, nor is there any evidence where the state contacts Ms. Cholota. Now they try and say, no, we contacted Victor Nkwashu and asked him, is your client coming back to the country? My lord, that is neither here nor there, and that is not credible evidence, as it is known that the state itself told Mr. Nkwashu and Ms. Cholota that they were not to have any contact with each other. And so to ask Mr. Ngwashu that, oh, have you had contact with your client when she was no longer their client? It is neither here nor there. And they don't show any communication beyond that. They don't show them ever emailing her to say, do you have any intention of coming back? The matter is on X date. And so again and again we see, my lord, that the only authority for the fact, and I put that in inverted commas, the fact that Ms. Cholota is a fugitive comes from one person and one person only, and that's the senior prosecutor. And there's no evidence to support that assumption by him that Ms. Cholota is a fugitive from justice. And so I would have thought, if I was trying to disprove my own case, I would have thought that the main thing I would have done was to establish, before anything else, establish that this was indeed a fugitive from justice and that the extradition was sound and necessary. But what the evidence shows is that there was never any need for an extradition process. There was never any need for this woman to suffer the way that she was made to suffer. No need whatsoever. Had they just sent an email, just as the Zondo Commission investigators did, she would have come back, which is why she had indicated in all of the communication, Mr. Ngwashu's main thing is that she has indicated that if she's contacted, she will come back. And no one has disputed those emails from Mr. Ngwashu. In fact, they rely on them. And so tacitly they accept that indeed that is what Mr. Ngwashu had said. Now, then we get to the third one. My lord, this is my favorite issue and favorite ground in this entire trial. The squabble about Ms. Cholota being a flight risk from Kenya. Now, both witnesses, but in particular Captain Collins, their testimony, and since the state has not at all summarized the testimony of their own witnesses in this case, his testimony in this regard was that he tracked Ms. Cholota's movements. He did a movement search, or he tracked her movements, and he found that she had connected at multiple locations.
Who are you referring to now?
Captain Collins.
Thank you.
His evidence was that he, as the investigating officer and a member of the Hawks, had tracked Ms. Cholota's movements to see whereabouts she had been, and he then tracks the multiple destinations. And the main thing that comes out of that is that when she traveled, whether she was traveling to South Africa or elsewhere, she had connecting flights in Ethiopia and connecting flights in Kenya. Connecting flights. Under oath, during cross-examination, his evidence was that he had no evidence that she was ever in Kenya beyond the connecting flight, and that he did not know where she then flew to. So after the connecting flight, his evidence and the state's evidence is that they do not know where after she flew to. And so that tells us that Captain Collins, when he did the movement, tracked Ms. Cholota's movement, he knew that those flights were only connecting flights. His testimony was that he then took that information and presented it to the senior prosecutor. That was his evidence, that he never told the senior prosecutor that Ms. Cholota was a flight risk. He never told the senior prosecutor that she had connections in Kenya. He simply presented, according to his evidence in the transcript, that this is where she flew to. I only have the connecting flights, and these were the connecting flights and the airlines. In communication with the United States, for no reason whatsoever, it is communicated to them that Ms. Cholota is a flight risk with connections in Kenya. That is the statement. Thereafter, and I'll go back to the implications of the statement, but thereafter, after that statement, there's repeated attempts by the state to have us believe that that was a bona fide mistake. When the witness was in the witness box, my lord, the question that was put to him was, then why was the mistake not Ethiopia and Kenya, and it was connecting flights? She's never been there. A story was spun. We couldn't understand what the actual thing is. Oh, she's got a son in Nigeria. Oh, but at no point is it explained to us why was what was communicated to the US explicitly. This fugitive has got connections in Kenya. But when you look at the implication, even from the most uneducated eye, what the US must have understood was that this was a fugitive that needed to be detained because she will flee. And so there's multiple attempts by the state to convince us that that was not the case, despite the fact that it's common cause that she spent 4 months in prison and that there was an opportunity for her to be released, but she was detained on that basis. It's common cause. But the state denies that their statement that this fugitive was a fugitive that was a flight risk and that her connections were in Kenya, that statement was neither here nor there. It was a mistake. It was a momentary lapse in judgment. We say that that cannot be. I do not understand formal documents and formal affidavits to a state such as the United States to have such mistakes or errors, because there's no other error. There's no other error that they've committed. Everything else is correct and was verified according to them. But this one, it's an error. It's a mistake. They don't know how it got there. My Lord, that version simply does not hold water. They knew what they were doing. They knew what they were doing. They knew what they were saying. They knew the implications. And if they did not know, because they are the state and they are the national prosecuting authority, they ought to have known. This bona fide error, that cannot stand. We do not buy that at all. But also further to that, my Lord, even if at a stretch we can say it was a bona fide error, it does not cure. There's nothing where it says that because they were good-natured in their mistake, then that's not still a mistake. It's still a mistake. And it's still something that led to her being detained for 4 months. And it's still something that led to her being extradited, because it reinforced the claim that not only was she a fugitive, she was a flight risk and she had connections in other countries. When she had none of that, when she was neither fugitive nor a flight risk, nor had connections. The gravity of such a mistake from the state is simply unbelievable for a prosecuting authority to state that's the type of mistakes that they make in official documentation. It simply cannot stand, my Lord. It simply cannot stand. Then we state in our heads of argument that the part about the kickbacks, the facilitation of the kickbacks and being part of a syndicate, that is by and large quite clearly not true. Because even in the main trial, when the preamble of this asbestos matter was read out by the prosecution, no way did they state that this entire asbestos matter is a syndicate that was run and in which Ms. Cholota facilitated these kickbacks for Ignatius Mbamba. It appears nowhere. The only time it appears that the word syndicate, and I do put it to the state to please point us to where in this matter, in this main trial in South Africa, a syndicate is ever mentioned and Ms. Cholota facilitating kickbacks is ever mentioned. It isn't, my Lord. It was mentioned in the documentation to the United States to strengthen a case that did not hold water. And we know that it did not hold water, my Lord, because a letter from the U.S. Department of State was led as evidence. And that letter set out the multiple instances that U.S. authorities were simply not convinced of South Africa's case. They kept having to clarify multiple things, and we set out the dates in our heads of argument where they repeatedly ask. And if I may just go there for purposes of clarity.
You know, page 25, I think. Paragraph 58.
Yes, but I think let me go to the specific document where I have written it out, my Lord, so that I can state the dates. And perhaps my attorney, if need be, I don't think there will be a need, but if need be, perhaps we can circulate. But let's start The letter, I don't know if my lord has the volumes.
Yes, I do.
That's volume 1, page 88.
Yes, thank you.
So that letter is dated 26 January 2023, and it records the sequence of events. So we cannot dispute, or rather it was not disputed, that it is incorrect. And so we can assume and we can accept that what is recorded in that letter by the U.S. Department of State is in fact the truth, because this was documentary evidence that was presented by the state. But it states there that they conducted an initial review of the extradition paperwork. So they record that the request was received on 18 April 2022, and an initial review was conducted on the extradition paperwork. Now, in a perfect world, obviously it's not a perfect world, but in a perfect world, I do not deal with extraditions, but I imagine multiple iterations of the document would have happened within the NPA. There was no evidence of such, but I imagine that this was not the first draft that was sent to U.S. officials, that it was at least vetted by officials. But the U.S. says that they received the paperwork, and then they sent, on 13 June, a request for further information. And they state there what it is that they sought. They said they sought an explanation of the elements of the offenses and Ms. Cholota's connection to the fraud scheme. So on Ms. Cholota's connection to the fraud scheme, the scheme that they said she was paying kickbacks to Mr. Ignatius Mbambane. So the U.S. said, we've received your extradition paperwork, but we would like an explanation of the elements of these offenses. It will be recalled that she was charged with fraud, money laundering, and corruption, and then alternative offenses such as theft. And so they wanted an explanation of the elements of these crimes, and also the connection that Ms. Cholota had to this fraud scheme that they've just explained. And so it was not evident on the papers that they received. They specifically stated Ms. Cholota's connection to the money laundering charges, and then they sent South Africa a link to help them understand that probable cause is required. This tells us that the United States Department of Justice could not establish probable cause on the extradition paperwork that had been sent by South Africa to the United States, and that is why they were seeking that. And they explain to them why. They say a U.S. court will require a demonstration of probable cause that the fugitive committed the crimes upon which the extradition is sought. And so we see there that they were under the impression that this individual was a fugitive, and they wanted the connection of how does she connect to this fraud scheme. So South Africa sends, according to the U.S., South Africa sends 2 updated drafts of the prosecutor's affidavit, and they send this on 18 August and 11 October 2022. And what does the U.S. say in the letter? The U.S. says a number of questions still remained. So there's an extradition paperwork, the original extradition paperwork with all the affidavits and supporting documents. It's sent to the Department of Justice. They review it. They come back. We need to understand, how is this person connected to this fraud scheme that you've just described, and what are the elements of these charges that she's charged with? They send 2 updates. The U.S. says, we still just don't understand it. May I interject here, my lord? It is my submission that if there was, it would have been evident. There wouldn't have been a further update and a further update necessary. If there was a connection to the fraud scheme, it would have been evident in the papers that they sent. If there was a basis, a reasonable and probable cause for her to be charged, it would have been evident in the extradition framework and paperwork that they sent. So that's the first try by that's the second try by South Africa. Then the United States officials, they record in the same letter that on 30 November, they had a conference call. So let's stop writing to South Africa. Let's have a conference call. Perhaps we're not clear enough. And they tell us why they had this conference call. They say to try to resolve the remaining issues. But ultimately, we were left with open questions as to whether the facts supported the proposed charges. The first batch of affidavits and supporting documents are sent. The United States has questions. The second and third batch is sent. The United States says, maybe if they see us in person and we see them in person, and we discuss this virtually, we can understand what is happening. But what do they say? They say questions still remained. We were left with open questions as to whether the facts supported the proposed charges. Again, I interject, my lord. If there were facts to support the charges, they would have been evident in the papers. They would have been evident to U.S. officials, because they were not sending this to the U.S. Department of Media and Entertainment. They were sending this to the U.S. Department of Justice, that probably has dealt with thousands of these types of requests. And so they know what they're looking for. And so if it was there, if there were facts to support, they would have been evident in the papers. But they go further. This letter was so instructive and instrumental to this case in summarizing just how much or how little this extradition request and these extradition aims by the state had gaping holes. They say that on 12 January 2023, so the following year, they started in 18 April the previous year. The following year, the U.S. Department of Justice says prosecutors provided additional information on the legal analysis of the proposed charges, but did not provide additional factual support for those charges. This is now a fourth time. They provide an analysis of the proposed charges. So to say money laundering is a crime such as this in South Africa, and it's clear in the exhibit that was submitted by the senior state prosecutor. But the U.S. says, but they did not provide additional factual support for those charges. What does that mean? That the facts that show, okay, we understand what the charge is, and you've explained to us now what the elements of these charges are, but we still don't understand how this fugitive, Ms. Cholota, how the facts in relation to her support these charges. And that's because it was unsupported. And we'll go back to why it is that she was charged again. But it is clear here from this letter, because these people had no background. All they were dealing with was the information before them. So we cannot accuse them of bias, or we cannot accuse them of bias in favor of Ms. Cholota. It was a purely objective exercise from where I'm standing. But if it was a subjective exercise, we stand to be corrected. But it seemingly was a purely administrative exercise. Then they state that the primary concern is that the extradition request, and this is where, my lord, it is crucial. They state, the United States states, that the extradition request does not establish probable cause that Ms. Cholota in fact knew of and participated in the scheme from which all the charges in the indictment arose. The United States Department of State tells the South African officials that notwithstanding all of these attempts to show probable cause and a factual basis for these charges, the request did not establish that. The request did not establish probable cause that not only, and they distinguish, my lord, they say it does not establish that she knew of and participated in the scheme, because for sure there would have been charges where she knows of the scheme and she does not, as an official of government, as a public official or as a public servant, that she knew of the scheme and she does not tell the relevant authorities. But the US bands it together. They say there's no facts that you've provided that show us that this fugitive knew of the scheme. Further, there's no evidence that you've provided, notwithstanding all the attempts, that show us that she participated in it. Then they state that there is no additional factual basis to support the theory that she knew about or was involved in the scheme put forth or approved the fraudulent asbestos removal contract. And then they stated in brackets, or even that she knew it was illegal. Now, if I can put that in layman terms, to the United States it was not clear. How does a PA know about an asbestos contract and how does she participate? Show us in the facts. We've asked you 5 times, you have not showed us. That is what the United States said, and they recorded it. Such was their concern. They recorded it in official correspondence, that we just simply do not have the required evidence to show that this fugitive, the so-called fugitive, participated in this, that she approved this fraudulent contract, or even that she knew it was illegal. And then they tell them that we do not believe that there is probable cause to support these elements in the material we've been provided. That is about as clear a statement as we can get, that notwithstanding the multiple attempts by the NPA and its prosecutors to try and establish a factual basis for the charges against Ms. Cholota, they simply could not. And once again, my lord, I go back to my original statement. If there was, it would have been evident. The fact that it was not leads us to assume that there was no such factual basis. But what does the state do, almost conveniently, after all of this? On the 6th of June, because that's what the report is dated, on the 6th of June 2023, after this communication, they have a report commissioned. And miraculously, that report says there's factual basis that Ms. Cholota has connection to these charges. And so this report was not in any of the documentation prior. It was not sent to the United States. If it was, it would have been evident and the United States would have recorded it. And in the witness testimonies, they themselves agreed that indeed this report appears on 6 June 2023, which is why the date is 6 June 2023. Now, time and time again, there's this almost brushing off of the coincidence of the procurement of that report and the fact that it contained all of this so-called information. Interestingly as well, the report says none of this information, we do not confirm that any of this information in this report is accurate, and we are not to be held liable for any inaccuracies in the report, which is very peculiar. Very peculiar to me, particularly as the consequences of that information mean prison time for Ms. Cholota. But the authors of that report state that if there are any inaccuracies, we are not liable. And it is coincidentally procured after the United States has said they do not have factual basis. If we were not involved in this case and we were looking at this objectively from afar, the writing would be on the wall that this report was procured to cover the gaps that the United States had in the state's case. Because all of a sudden, after that report, the United States says, okay, and what does the magistrate say? The magistrate, in considering whether or not Ms. Cholota is to be certified as extraditable, says that she considered 3 things. She says that she's considered the report, she's considered the prosecutor's affidavit, the one where she's supposedly a fugitive with connections in Kenya and a flight risk, and that she's considered the investigating officer's affidavit. So those three affidavits are what were relied on, or those 3 documents are what were relied on for the magistrate to say, indeed, she is extraditable. Now, if we take that and we consider that the state on its own version is saying that there were some misrepresentations in Advocate Dineshan's affidavit. That is common cause. They say that themselves, but they say the intention was not to mislead. But they do say that that was an inaccuracy and that was a misrepresentation. Captain Collins, in his evidence as well, stated that that is not what I told him. I told him she'd gone to multiple countries and I don't know where this flight risk and fugitive stuff comes from. So if we accept that that affidavit had inconsistencies, had misrepresentations, and then we also accept that the report that was procured on 6 June 2023, that all of a sudden had factual bases, but none that anyone is liable for if they're proven to not be true. And Captain Collins, and we're going to get to Captain Collins, if those are the 3 documents that she was proclaimed extraditable on, if that was the basis, then just by that, my lord, the extradition is unlawful, because every single one of those documents is questionable. And it was not established through the trial that those documents could be relied on, because even Captain Collins, and we're going to come to his evidence, seemed to stray away from some of the matters in his affidavit that had been sent originally with a DPP Navila Somaro's affidavit. So we have to then go back to this probable cause, because this is where the gist of what the Constitutional Court has asked us to do lies. The Constitutional Court says, yes, we agree and we accept that it was not the Director of Public Prosecutions that was supposed to request the extradition. It was, in fact, the executive. And on that basis, Ms. Cholota's extradition is unlawful. That's what the Constitutional Court says. It goes further and says, but that notwithstanding, that does not automatically mean that this court does not have jurisdiction. What would be desirable would be that the 4 remaining grounds be adjudicated upon. And if it is such that those grounds present such an affront to the public conscience that they would present, or that they would run counter to the administration of justice, and that this court, exercising its discretion, could not possibly come to the conclusion that it has jurisdiction over Ms. Cholota, then the extradition is unlawful. And then this court cannot exercise a jurisdiction over her. So we must look deeper into what exactly it is about this conduct that is an affront to the public conscience. Now, my lord, the main or the material facts, and I will get to what they are, do not appear to have been disproven by the witnesses in the trial within trial. In fact, they agree to the material facts, and I'll get to what the material facts are that bring us back to the 4 grounds. And so, again, the so-called ground that the state has that Ms. Cholota should have been put in the box, and because she wasn't put in the box, the defense cannot say that it made its case. Forgetting, we have no such case to make. The case is the state's to make. And if we were of the view that on the basis of the evidence that they have given, they have not made out of case, and they have proved what we have said, there was no reason for us to bring Ms. Cholota. Because what would she have said? She would have confirmed, just as the witnesses confirmed, that she was interviewed on 22 and 23 September 2021. The witnesses confirmed that for us. She would have confirmed that the recording or the transcript of the meeting was in fact the recording and the transcript of the meeting. The witnesses confirmed that for us. They stated that that document was in fact an accurate recording of what happened in that meeting. Ms. Cholota would have told us that FBI agents presented at her door and asked them to accompany them without her knowing where she was going. The witnesses confirmed that. They said that they were not there, but they could see that FBI agents presented at Ms. Cholota's door and that they came out with her. They confirmed to us under oath that this was early in the morning. I recall, in fact, that we were trying to establish what time exactly, and we landed at or about 7 a.m. That was the witnesses' testimony. Ms. Cholota would have testified the same. The witnesses confirmed that Ms. Cholota drove in her own car. There was the FBI agents and themselves. the two witnesses, Ms. Cholota would have also said that. They confirmed that for us. They confirmed that they then got to the Sheraton Hotel, and that's where she was introduced to Major General Gerber and Captain Khalid. The witnesses told us that. They then state that she was then taken into an interview room. But if one will recall, questions were put to both witnesses that, did she know you were coming? No. Why didn't you tell her that you were coming? Because maybe she would have run away. Had she run away before? No. On what basis did you think she was going to run away? We just thought. That was their evidence. Ms. Cholota would have confirmed that indeed they did not tell her they were coming. And then they confirm in their testimony that they were going to record the meeting because at the time she was still a witness. Ms. Cholota would have said that as well. They confirmed that for us, that there was an intention to record the meeting. But on the witness's own testimony, they never recorded the meeting. They said that something broke, which was very interesting to all and sundry because you go all the way to the United States to interview a witness and then you don't have recording equipment to record that interview. In the transcript, almost on the first or second page, immediately Major General Gerber is talking about, do you know what a Section 204 witness is? Now, a Section 204 witness is someone who has been charged, but who has made an agreement with the state that they are going to now become a witness on behalf of the state against whatever accused. There was no basis prior for that. But what that shows us, and this is my submission, my Lord, is that that was already at the back of their minds. Because there was no conversation that they had had prior to that with Ms. Cholota about that. Ms. Cholota had never contacted them to say, hey, I think I might just want to be a 204 witness. Nobody had mentioned 204 witness. And when it was put to Major General Gerber, why would you talk about 204 witness when she had agreed to be a witness in the email? Or she had said, fine, come interview me. He could not tell us. Oh, it was just, I was just mentioning it. We even went to the section, my Lord. I even took him to the section in the Criminal Procedure Act to say, but there's a procedure. You can't just pronounce it upon someone. The court needs to be involved. The person needs to agree. Yes, but. The transcript clearly shows all of that. That was what the witnesses told us. And that is what Ms. Cholota would have told us. She would have told us that before I even sat, they were talking about 204 witnesses, and I was confused. And it's clearly indicated in the transcript that she was confused. She didn't know what it was. Then the witnesses tell us that, and I go back now to the previous founding affidavits that they had submitted in courts. They had said in the Constitutional Court affidavit and in the High Court affidavit that came before Yefer that they had put documents before Ms. Cholota. In fact, that was such a widely repeated statement that even media reports, when they were talking about how Ms. Cholota went against cooperation with the state, they would also repeat that documents were placed before Ms. Cholota and she then became uncooperative. But what in the trial within a trial happened is that it was clearly evidenced that no documents were placed before Ms. Cholota. Now, instead of the witnesses saying, oh, I suppose then we either lied in the affidavits or we were mistaken in our memory, they say, no, it hadn't even come to that, didn't even come to that. Granted, but their own evidence was that they didn't even have the documents with them. That would have also been Ms. Cholota's evidence, that they did not have any document with them. I didn't see any document. They didn't place anything. But the witnesses told us, the state's own witnesses told us, we did not have any documents. Then the transcript talks about how they asked, do people give 10% of their tenders? Are you aware of that? There's clear indication that Ms. Cholota was confused. What? No, are you aware that people had to give a bit of money? In the email, my Lord, that the state prosecutor had sent to Ms. Cholota, he had assured her, and I use the word assure very intentionally, that we will not ask you questions about things that you don't know. And I quote verbatim, we will not ask you questions about things that you don't know. But they continue to ask her about things that she doesn't know. It's in the transcripts. the witnesses stated that the transcript was an accurate representation of the meeting or recordal of the meeting. And so what we know is that A, she did not know they were coming. She was not prepared for any interview or questioning from the investigators. They came to her residence in the wee hours of the morning with FBI agents. And my lord will recall within the trial, when it was put to the two witnesses, why did you come with FBI agents? No, it's the jurisdiction of America, and so, and so, and so. Why didn't you just email her? Please meet us at X place. Why was there a need for the FBI to come to her door? 3 men, 1 woman. That was common cause too. And they just could not answer, my lord. The version we place before this court is that it was for intimidation purposes. Because if any person is watching what is happening in the United States right now, even one agent at your door would put you in a state of terror. How much more 4 in a state that you are not a citizen of? 4 FBI agents, unannounced, come to your house. And in the letter, in the correspondence with the senior state prosecutor, she had already recorded that she does not feel safe. She states that to the senior prosecutor, and the witness confirmed that he was copied in that correspondence, and so we know that that correspondence is accurate. She stated there, I do not feel safe anymore. What is happening? Especially because the FBI already visited me. So what the state knew at that time was that Ms. Cholota, being a student in the United States, was frightened by the FBI coming to her door previously. That is why he assured her and said, you have nothing to be afraid of. That is what the prosecutor told the witness. And yet on even day, they present with 4 plus 2 Hawks officials. And then the witnesses want to be very, very unaware that this might be an intimidating situation for anyone. They say, no, we brought the woman because we thought Ms. Cholota might find comfort. And when they were pressed, why would she need comfort? No, because, well, she was a woman. But if there was no reason for Ms. Cholota to fear, which was my line of questioning, if there was no reason for Ms. Cholota to fear, why would there be a woman brought to make her feel at ease? Even there, the witnesses couldn't give us a clear answer. But what was clear was that it was understood by anyone that 4 FBI agents presenting upon Ms. Cholota's door, there was no reason for it, really, other than intimidation. And there's nothing where the witnesses have shown otherwise, that that was a necessity. But then, beyond the questioning, it appears in the testimony, my lord, or rather in the cross-examination, that there's a portion there where Ms. Cholota says, I have not even bathed. That's put to the witnesses. Were you aware that she had not bathed? Yes, we were aware. Why is that? Why was a witness at a witness interview with the FBI not having bathed? Even there was levity to it. Oh, I shower in the evening, said Captain Collins. So I don't know, maybe that was her preference. That's what a state official under oath is telling us about this sequence of events. When anyone with any understanding of the right to dignity and what that entails would understand that that was a very undignified way to treat a witness. In fact, that's an undignified way to treat a criminal. But at that time, she was a witness. But still, there was levity to it. No, it just was one of those things. I shower in the evening. There, it was neither here nor there. My lord, our submission to this court is that even that was on purpose. Because as we know from the history of this country and from other countries that have dealt with difficult pasts, hygiene and food are one of the main ways to torture someone. To leave them in a room unwashed day after day after day, because that does something to the psyche of an individual. That could not have been news to the police officials. And so it could have been known that if we come to her house and she does not know that we're coming and we ask her to come with us, in all probability she will be unwashed. But then there was a question that was put to the witnesses. Why couldn't you just wait? What harm would it have done for you to wait for her to shower? The FBI was already there. You guys were already there. At most 1 hour, 2 hours for her to wash. What was the hurry? They could not answer us. They could not answer us. Because again, there was no predetermined time. And so we could not say, oh, we were chasing 10, and so if we had waited for her, then 10 a.m. would have hit. Or we only had the Sheraton Hotel for 3 hours. There was no reason. Our submission is there was a reason. It was to subject this woman to cruel, inhumane, and degrading treatment. There was an intention there to treat her in a way that was degrading and intentionally cruel. There was no other reason for them to do it, my lord. That is our submission. Then it moves on. They ask her, the transcript clearly shows what happens. They ask her, but at no point is she asked about the Zondo Commission affidavit she had been told she was going to be asked about. When it was put to the witnesses, why didn't you ask her about the Zondo Commission affidavit? They could not answer. But most crucially, they had not even brought it with them to the United States. That was Captain Carlos's evidence. It was put to him. Did you even bring it with you? No. Why? We didn't even get to it. Yes, granted you didn't even get to it, but you didn't know that you were not going to get to it. And so if there ever had been an intention that in the first place she was going to be shown that Zondo affidavit, it would have been there somewhere. Just as I've got a judgment from Ibrahim, it's not to say that I will refer to that judgment, but I have brought it with me in case I need to refer to it. But he had not even brought it with him to the United States. Our case is that because that was never the intention. The intention was never to question Ms. Cholota about the Zondo Commission affidavit, the one where she explains how it came to be that she had interactions with these businessmen, the one where she explained to the nation on national television that no, yes, I knew this businessman, I was a PA when it was sports awards, when it was this. That's where she had explained that. They did not bring that. Now, when this same witness in an affidavit then states that the reason this person was charged was because she would not incriminate Ace Magashule, and we have an interview in which attempts are made by these two police officers to get her to incriminate Ace Magashule, and she will not, then his evidence is true. Then this court must accept that version, that because she would not incriminate, she was charged. Because then towards the tail end of the interview, and then on the witness's own testimony on what happened the day after, they then told her, you are not being cooperative. You are not giving us what we came here for. And we are going to give you an opportunity. That's their evidence. It's in the transcripts. We're going to give you an opportunity to go home and think about the answers you've given us here. If my lord were to say that to me, that Ms. Makapela, you have not made the arguments that I have wanted you to make, my understanding of that would be that the arguments I have made up until this point are not the arguments that my lord is looking for. And so when that is stated to Ms. Cholota at the end of the interview, that tells the witness that what you have told us is not what we are looking for. But they go further and they say, if you don't cooperate tomorrow, you will leave us with no choice but to charge you. That is the information that she is given. Now, when it is then characterized that, hey, South African officials, that is a clear threat. In the bail opposition affidavit, Captain Carlos says, no, that's not a threat. That's just a fair warning. In the testimony, in his oral testimony, when that is also put to him, when you say this to a witness, Captain Carlos, it's a threat. No. That's not what that was. I was just putting things to her. And he states it. And in fact, we summarize it in our heads of argument exactly what he said. He said, at page 11 of our heads of argument, paragraph 22, and we reference there record volume 9, page 863, lines 13 to 16. So after all the back and forth in cross-examination, he finally gets to this. He says, I gave her the choice that either work with us and tell us what you knows, or get advice, and then we follow the route, her being a suspect. And they insist that is not a threat. My Lord, I would be terrified to know what it is these officials consider a threat if this is not a threat. If to say to someone, if tomorrow we interview you and you're still giving us these answers, you will leave us with no choice, but we're giving you a choice right now. Either work with us and tell us what you know, or tomorrow we're going to charge you as a suspect. Now, it was put to the witness. Why not make her or declare her as a hostile witness? Because it is trite that if a witness is difficult, witness is not forthcoming with information, there are a myriad of options, my Lord. The court can hold the witness in contempt of court. The witness can be declared hostile. The witness can be taken, if they've contradicted information, they can be taken to the affidavits and told that actually this is perjury if you lied under oath. There's many ways that you can actually tell a witness you actually have to be cooperative with the court. But they go the other way. They go charges. And not accessory to corruption or, no. The same exact charges that Ace Magashule was being charged with. That lets us know that that was a clear threat. Because why would you charge her with the same exact charges? An example of this that I may bring to modern day, my Lord, is if in the current commissions of inquiry, there is a businessman that is found to be implicated in kidnapping, and a witness, let's call this witness L, before Loiso, the witness refuses to incriminate this businessman. Instead of the witness being told, you're going to be in contempt, or the witness being told, maybe then you were an accessory to the kidnapping, the witness is charged with the same kidnapping. Even just conceptually, it makes no sense. Even just conceptually, why would the witness be guilty of the same kidnapping that the businessman is charged with? And when it was put to the witnesses, balance us, Captain, how does it come to be that those are the charges that you charge her with? Where does money laundering fit in with the PA? Where does the PA fit in with money laundering? Where does the PA fit in with the fraud and corruption? Why not an accessory too? Why not, if let's say she had attempted to conceal documents, why not obstruction? Why the exact charges? That lets us know there was no thought put on this threat. At the time, it was simply just a threat to have her act in a particular way. So the following day comes. That too is common cause. And so Ms. Cholota would have told us that on the second day, I went for questioning again. But this time, and it's very interesting to note, my Lord, this time the interview is at the South African Embassy where recording devices are not allowed. We asked Major General Gerber, why? Why was it important for it to be at the South African Embassy? Especially because the transcript says that the actual initial intention was to hold it at the hotel that yourself and Captain Garlitz were staying at. He has no answer. The witness says, no, we just decided. It's very peculiar from where we are standing, my Lord. And again, because our case is that there was intention behind every single act, to have the witness be interviewed in a room where recording devices are not allowed is a very interesting choice on the part of the officials. And so, still thinking that she's safe, Ms. Cholota goes to the interview on the 23rd of September. By now, depending on which affidavit of Captain Garlitz's you believe, they had either spoken to the state prosecutor and said, if she continues this, we're going to have to charge her, or they hadn't. Because in one affidavit, they say that they had that discussion before, and then in another affidavit, they say, no, we called him afterwards. We called him after we had charged her. Multiple versions. But the common cause facts are that the South African Embassy, when Ms. Cholota stepped into the South African Embassy, she was a witness. When she stepped out, she was a suspect. And the only thing that caused her to be a suspect was that she would not implicate the person they wanted her to implicate. Because she had given them the information that I don't know what you're talking about here. I have the Zondo Commission affidavit. This is what I said in my statement. And so I don't know about this contract. I don't know about this contract. But according to the witnesses, they just did not get what it is that they wanted. Then we pressed them, Lord. We said, okay, then give us an example of what it is that you wanted. If one will recall, they made the example that, well, whenever we asked her who gave you that instruction, she would say it was the office of the Premier. And we needed names. That was their evidence. And she would not give us a name. Then it was put to the witnesses, okay, but there were multiple people in the office of the Premier. Did you interview any of them? No. That was the evidence. No. Why? Why, Captain Collins? There were about 5 other names. And we put the names to them because they appear in the transcript. What about this PA? What about this CFO? Did you interview this person? In other words, the people that would have known about whatever questions you're putting to Ms. Cholota, did you ask any of them anything? No. Why? Because, my Lord, and this is our submission, the intention had always been clear. The interview with Ms. Cholota was not an interview to help them understand the workings of the machinery of the Office of the Premier. The interview had a single purpose, and Captain Carlos already confirmed to the Constitutional Court what that purpose was. It was to incriminate Mr. Magashule. And so when she failed to do that, that's when they said, well, you leave us with no choice. We are going to charge you. Ms. Cholota would have also stated those facts because she states them in all other affidavits under oath. But then, she then says, and Captain Carlos confirms this, she then says, I would like to speak to a legal representative. Because by this time, it was clear to her that this is not a witness interview. The witness says, what did he do? He stopped writing, and this was his testimony. He stopped writing. He stepped out of the room that they were in the South African embassy, and he asked the gentleman that happened to be stationed nearby, hi, is there a lawyer here? It's like if I were to step outside there, my lord, and just security passing. Hi, is there a lawyer here? That's what he did. That was the extent of his ensuring that this suspect attains legal representation. Now we know from the plethora of case law that that is not sufficient, and that when an accused or a suspect requests legal representation, the official has to stop everything. And until that legal representative is present, only then can they do whatever it is they were doing until that point. And the witnesses stated that they knew that. And then when they were asked, then why did you continue? The levity returns, my lord. Well, because it was just a warning statement. That's the evidence. That's what he says in the transcript. That's what Captain Carlos says. It was a warning statement. But why did you continue in drafting the warning statement and having her sign? Well, because I looked for a lawyer and none was available, and so I continued. And there was a back and forth. But why did you continue? He was taken to the preamble of the warning statement that states there, if the suspect asks for legal representation, you have to stop taking the warning statement until a legal representative is there. We took him to that. Captain Carlos, this is what it says in the warning statement. Why didn't you stop? There is no answer even for that. Now, in the heads of argument of the state, a very interesting thing appears, my lord, and I'm shocked that this would appear in the state's heads of argument. They state that legal representation is not an absolute right. In other words, justifying why it's okay for a legal representative to not be present when an accused person asks for one. The very office responsible for ensuring the rights of accused are not contravened. They state in their heads of argument that legal representation is not an absolute right. And so the fact that the warning statement continued to be taken, despite Ms. Cholota having asked for one, and Captain Collins confirmed that she did in fact ask for one, The fact that they continued is neither here nor there. And they continue, my lord. They then tell this court, the state does not wish to rely on the warning statement. It will not, in the main trial, the state will not rely on the warning statement. So, whatever gravitas or whatever reliance you wanted to place on the warning statement, don't think about that now. We will not even rely on it. That is not the point. The point is you're not allowed to do that. The point is you are not allowed to do that. The point is it is against the law to do that. The point is, if Ms. Cholota had asked for a legal representative, one should either have been sought for her or the proceedings should have been cancelled, and then only after she gets one, continued. Again, our submission is that there was no intention of being fair to this woman by those two state officials. And so denying her legal representation was not a big deal to them. Because who is she in any event, according to them? And the state then sanctions these actions and says, yes, our officials can do that. Our officials can deny someone the right to legal representation because it is not an absolute right. Now, when the Constitutional Court asks us to come and show them or show this court what in the conduct of the officials presents an affront to the public conscience, what presents, what is counter to the administration of justice, this is one of the central points that this court ought to consider. That it cannot be that conduct of such a nature is sanctioned. That it cannot be that this court says in a judgment that legal representation is not an absolute right. And if state officials ignore the right to legal representation, then that's fine. It's not. The very basis of this country's history is that people were denied the right to legal representation, and it is one of our founding values for that very reason. Again, because we state that this was a systematic, intentional series of events, it checks out with everything else. It accords with the way that they were treating her this entire time. Denial of legal representation was one of the foundational values of what they did in the past. That was one of the main mechanisms how you found people in prison for continued periods of time being denied the right to see a lawyer, tortured day after day. It checks out. And so the fact that the state then in the heads of argument tries again this levity thing of it was just a slip of the mind, it was just a mistake. None of it was a mistake. Our case is that none of their actions, when considered together, was a mistake. In fact, it was one of the most brilliantly executed plans. It's just a shame that the witness did not fold, that Ms. Cholota did not fold. Otherwise, it was a perfectly executed and planned agenda. So she walks out of the interview of the 23rd of September a suspect. But from that day until she's told that she's a fugitive, there is no communication by the state. So from 23 September 2021 until 2022 April. Actually for her, I think it was August because she was told by the Director General, according to Captain Carlos's witness testimony, the Director General wrote to Ms. Cholota and said, you are a fugitive. And because you're a fugitive, you're wanted. And so we have to terminate your bursary. That's what the letter says. It was attached by the state to their papers that were presented to the Constitutional Court. And when Captain Carlos was pressed, because the information was not volunteered, how did the Director General come to understand that Ms. Cholota was a fugitive? Who told him? There was a bit of a... But with further and further questioning and the cross-examination, finally the truth came to light. It was Captain Carlos and some few members of the Hawks who went to go see the Director General and tell the Director General that this individual was a fugitive. What evidence they presented to the Director General to support this, it is unclear. But what we do know is that the letter that the Director General sent said to Ms. Cholota, present yourself before me within 10 days to explain yourself. In other words, fly from Maryland, where you are busy with your studies, back to Bloemfontein, present yourself to me, and tell me why I should continue with this bursary. That was the evidence of Captain Khalid's, that they went to the Director General and they had discussions, according to him, that this bursary should be terminated. But, my lord, when again we are asked to present information and facts that are an affront to the public conscience, it is the following sequence of events that the evidence that was submitted by the state shows us. The Director General wrote to Ms. Cholota 3 times, and then on the final, she made representations via a letter. Therein she says, I don't know a thing about this, in the letter. It was attached to the Constitutional Court documents. She says, I don't know anything about this. This is the first time I'm hearing that I'm a fugitive. I have gotten good grades to maintain my bursary. I don't know what is happening. Please don't cancel my bursary. Second letter, the Director General says, no, I'm canceling it. Cancelled. It's important to note, and Captain Collins did confirm this, that the Free State Department, or the Free State government, by way of that bursary, was the sponsor for Ms. Cholota's studies. For the longest of times, we did not know how it came to be that her visa sponsor was withdrawn. But the letter that was provided by the U.S. Department, that was provided by the state, tells us that the U.S. Department of State, not knowing what they are confirming, says, Johannes, per your request, Johannes is the senior state prosecutor, Advocate Deportation, per your request, I notified immigration that Ms. Cholota no longer has a sponsor. That tells us that there was communication from South African officials by way of the senior state prosecutor to the U.S. to say, hey, I don't know if you guys know this, but she no longer has an active visa. What the U.S. Department of State then does is they tell immigration, now, my lord, there are current world circumstances that are going on that I think could better explain to this court the exact agency that came to arrest Ms. Cholota. It was the current agency that is wreaking havoc in America right now, ICE. That's who came to collect Ms. Cholota. And they detained her for 7 days. The same ICE that has been responsible for what now I think the tally is at 3 murders of U.S. citizens. Foreign citizens are unaccounted for. That is the agency that arrested Ms. Cholota on the instructions, or as the U.S. stated, per the request of South African officials. Specific South African official being the state, the senior state prosecutor. Now again, when we want to ask what behavior or conduct by South African functionaries is so deplorable that it would render a court unable in all consciousness to say that I will exercise jurisdiction over this person, it is that. Because they did not have to do that. The extradition process at that point was well underway, my lord. They could have just waited if in fact they had the factual, the necessary facts to sustain the cause. But they were struggling with the extradition, as we stated. And so what do they do now? They go to the Director General in the Free State government. They pressurize him. That is our version. According to Captain Collins, they spoke to him. They pressurize him, withdraw this bursary. And their consequent actions lead us to understand that they knew that withdrawing the visa would mean that she is an illegal immigrant of the United States. Because then there's communication where the senior state prosecutor, Advocate Deportation, clearly states, I would prefer deportation because it would be easier. End quote. I've quoted it verbatim. He would prefer deportation of Ms. Cholota rather than extradition because there were too many requirements in this extradition, one of which was factual basis to sustain the cause. And so if we tell ICE that she's illegal and ICE arrests her, then we can get her to be deported. That would be easier, says the state prosecutor. And it bears reminding that the National Prosecuting Authority is an agency that was created by the Constitution. Its mandate and basis are the Constitution. In other words, they should be the protectors of constitutional rights first and foremost. But here we have a clear concerted effort to infringe on Ms. Cholota's rights. She had done nothing. There was nothing that we can say she had done to deserve her bursary being taken away. But more than anything, she had done nothing to deserve a state prosecutor directing the U.S. to arrest her, knowing full well she would be detained by this agency that is currently killing U.S. citizens. The gravity of it, my lord, cannot be overstated. The gravity of these actions simply cannot be overstated. They were putting her life in danger, intentionally. All for the purpose of getting her back and getting back at her for not incriminating who they wanted her to incriminate. Because there's no reason for these actions. She had not killed anyone. And there was already a lack of basis to sustain the fact that she knew anything about this fraudulent scheme. She had not done anything to deserve this. But according to the state, she had. According to the state, this conduct, there's someone that is deserving of this conduct, and it is Ms. Cholota. What reason she was deserving of this conduct, they do not tell us. Now that is where every single South African and this court ought to be gravely concerned. We cannot have a prosecuting authority or officials of a prosecuting authority that think that that is okay. And we cannot have a prosecuting authority that does that, that puts a South African's life in danger intentionally. Now, I'm sure if they were in the box and we put this to them, again, the levity would surface. That no, we didn't know that if Visa is withdrawn, her life would be put in danger. But the email from the U.S. Department of Justice, Maria Lerner, is clear, per your request. So they didn't just inform the U.S. that she does not have a visa anymore because we have asked the Department of the DG to withdraw it. They didn't just inform. It was a request. She clearly says that per your request, I have now informed immigration, and they tell me that they've arrested her. Then the U.S. Department of State says to the senior state prosecutor, but there's a bit of a problem because she's still registered at her university, and so she was let go after 7 days. And they told her that as long as she's registered at the university, then she could continue to be in the U.S. Again, the fact that there is, on black and white, communication from South African functionaries saying that I would prefer deportation as it is easier. They knew that Ms. Cholota would be arrested by ICE. They knew that Ms. Cholota would be detained, and they were hoping that upon detention, she would then be deported. But that was not the case because, again, she was lawfully in the United States. She was there on a full scholarship from the Bay Atlantic University. One will recall that this was put to Captain Khalid as well. He was taken to the FTI report at the bottom, wherein it is recorded that attached is a letter, a scholarship letter, awarding the scholarship to Ms. Cholota. So she had the scholarship from this United States university, and then for living expenses and for textbooks, she had the bursary from the Free State government. What they had not envisioned was that the scholarship would save her. They had envisioned that if we take away the sponsor, she'll be left destitute and she will be deported. That is deplorable. As an officer of this court, as someone who knows what human rights are and what constitutional rights are, this behavior is deplorable. And this court cannot sanction it, that it is okay for state officials to do this. It is not. It is not, my lord. Now we move away from that. She's not deported. Now the extradition must then go ahead because they've clearly said she's a fugitive, knowing she's not. And they've tried time and time again to present factual evidence, knowing there is none. But then this FTI report comes about, and that is presented to the magistrate. Those are the three grounds that we state that there would have been no point for Ms. Cholota to take the stand because, as I've just summarized for my lord, all of this came about from the testimony of the state's own witnesses. There would have been no reason for her to come and confirm that. They already confirmed it. They looked at affidavits, they looked at documents, they confirmed that they were copied in communication, they confirmed that the transcript was the transcript, they confirmed all the material facts that I've just placed before this court. But we have to go back to the treatment in the interview room, because it's not just that it was unconstitutional insofar as from right or wrong. It is what we liken it to. It is behavior and conduct that this country said we will never allow in this country as long as the Constitution is still supreme. It is conduct that this country said for an individual to be abducted, we no longer do that because we are a constitutional democracy. For an individual to be mentally tortured, we no longer do that. We are a constitutional democracy. For an individual to have their dignity infringed in the way of being dragged into an interview without having bathed, not knowing who the officials around them are, in fear and not knowing what it is they're being called in the interview to do. We said, because that was done so much in the past and we are a constitutional democracy now, that behavior is not allowed. That is why Section 2 of the Constitution makes it clear that any conduct that is inconsistent with the Constitution is invalid and unlawful. It does not say if you intended to do it and then it's inconsistent. Then it says any conduct. So it does not matter whether or not Major General Gerber and Captain Khalid knew that their tactics were eerily similar to what the security branch used to do. It doesn't matter that they knew that. It is that that conduct was similar. They did detain her. Whether or not they want to say she voluntarily came, it's not voluntary if there's 4 FBI agents driving behind you having dragged you out of your house. It is not voluntary if you have not even had a chance to bath. And it is certainly not voluntary if you have 2 FBI agents outside the room while she's being interviewed. There's nothing voluntary about that. And so it can only be said that it is detention. In fact, there's case law where even a police officer stopping you for a breathalyzer longer than they need to has been held by the Constitutional Court to be detention. And so the fact that they say, no, it wasn't detention, she went there voluntarily, we even allowed her to see her boyfriend. My lord, objectively viewed, it is detention. Objectively viewed, it is abduction. And this being a constitutional democracy, we said that's no longer done in South Africa. And yet they did it. And they confirmed it on the stand. And we say that witnesses cannot be tortured like that. The Major General was given the definition of torture under Article 1 of the Convention. And he stated that, well, we didn't slap her. You can't say that she had any physical. And then it was put to him that, no, but mental torture. You can also mentally torture someone by subjecting them to mental pain and suffering. It did not seem that that was a concept that was familiar. But that is conduct that is contrary to the Constitution. Whether or not he knew that threatening someone with charges is mental torture or not, he threatened someone with charges, and it is mental torture. And so the behavior, and then over and above the legal representation that we've just traversed, and the multiple attempts at presenting false information, time and time again. So it cannot be a mistake, my lord. Every time they updated a document to misrepresent facts, that cannot be said to be a mistake. If they want to say it was bona fide, what about the second time they submitted it? What about the third time? What about the fourth time? What about the time when they were virtually meeting with the U.S. Department of State and still submitted these so-called bona fide errors? Was it bona fide then? No, it was not. They knew what they were doing. They knew what they were doing. At all times, they knew what they were doing. And so when one then now brings it back to Ibrahim, it was more or less the same. Now, in the appeal before the Constitutional Court, one of the state's or the NPA's main claims was that the conduct in this case cannot be said to be similar to the conduct in the Ibrahim case. But I would like to state that if what I have just explained now is not similar to the conduct in Ibrahim, then I don't know what is. Because in Ibrahim, the police went into Swaziland to go and try and coerce, or through cunning means, get this man back to South Africa. When he came back, he said, I'm not here voluntarily. I was tricked through cunning to be here. These are agents of the state that came into this country and then took me. I was not extradited by lawful process. The court then looked at the actions of South African authorities in that case, which is why it says that it is crucial for the administration of justice, and it says it in Afrikaans, it is crucial for the administration of justice that the state comes to court with clean hands. That if the state comes into court with conduct similar to this in Ibrahim, then it cannot be said that the state comes into court with clean hands. Now, if we take the heads of argument that have been submitted by the state, other than just deny, there's no way where they explain to us what is correct and constitutional about this behavior. They say there was nothing untoward here, that should worry us even more. That there's still an insistence that this behavior is constitutional and correct and lawful, when it is not. That should worry us even more, ever more, because an accountable functionary would indeed admit to some of the shortcomings, to say that perhaps now that it has been clarified to us and examples have been brought of the apartheid era and how the security branch used to conduct itself then and how these two officials conducted themselves, and the similarities are glaring. That was not our intention. And to the extent that that is evident, we apologize. That was what the state used to do. But here, they say no. You've seen what you've seen, but we still don't say we were wrong. In fact, we were correct. In fact, they accuse Ms. Cholota of exaggerating when she stated the facts in the different affidavits and the witnesses confirmed them. But the prosecutors inject their own understanding of what it means when a major general says, I was there and indeed this was how we treated her. To me, it's not torture. They want to rewrite that as though we were not all sitting in the same courtroom and heard him. In fact, anyone who was sitting in the courtroom observed the way in which his demeanor was towards me. And I'm just an officer of the court. But you can infer that if that is how he was on a public national stage, before an officer of the court and before a judge of the court, if that is how he was, then one can only imagine how he was behind closed doors with an unwashed young woman who did not know why she was there. And so the state can make light of this as much as they want, but to Ms. Cholota, it is not a joke. And to Ms. Cholota, it is not nothing. She has lost everything. She does not have a scholarship. She cannot travel anywhere. She's in her home, confined indefinitely. And what was her crime really? Her crime was saying to the Zondo Commission, oh, you want to fight corruption? I'll assist. I'll come and tell you what you want to know because I'm a responsible citizen. That's what she says in the email to Advocate Dinyashin. She says, I will help my country. That's what she says. Not knowing that the same officials of that country would be taking her almost to her death, asking ICE to arrest her and detain her. That was her only crime because they still have no factual basis to support the charges. So her only crime really right to legal representation. They do not tell this court, this is how it is permissible to question and torture a witness like this. Because we have to remember that this torture, this detention, this abduction was in relation to a witness. So that is what the state is saying, that it is okay to treat witnesses like this, as long as the greater intention is to fight crime and corruption. But it's okay. Nowhere do they take any accountability for what they've put Ms. Cholota through. Nowhere. Instead, they double down and they insist that nothing in what they have done is untoward. That cannot be, my lord. That cannot be. And so when taken together, when you take all three together, that there's nothing that shows that she ever was a fugitive, that she ever indicated that she would not come to this country. That there's nothing. If we accept that there's nothing, and I really would like to put that challenge to the state to show us where it is that Ms. Cholota being a fugitive is established. Show us the page. Show us the email. Show us the communication that establishes that this person had no intention of ever coming back to this country and she was a fugitive on the run. Show us that. Secondly, show us why it is that the investigating officer tells the Constitutional Court that the reason why Ms. Cholota was charged was because she would not implicate Ace Makashule. It's either the state has to say that Captain Khalid was lying to the Constitutional Court or that Captain Khalid was correct. Both things cannot be true at the same time. And there seems to be this need for the state to make, because they say the witnesses were reliable and trustworthy and honest. It's Ms. Cholota that's untrustworthy and dishonest. Then they say it's not true that she was charged because she wouldn't incriminate Ace Makashule. No, but we're not just saying that because Ms. Cholota said it. We're saying that because the investigating officer said it. And it is the investigating officer that recommends the charges. And so if he says that she was charged because she would not incriminate Ace Makashule, we have to accept that that is why she was charged. And not S versus Zuma, the National Director for Public Prosecutions versus Zuma, the Supreme Court of Appeal said, an improper motive is not enough. There must also be a lack of reasonable and probable cause. What the admission by Captain Khalid tells us is that her charges are based on improper motive. But more than that, they are based on there's no reasonable cause to sustain the charge. And we say that because if there was, it would have been evident to United States officials in the Department of Justice when they kept asking, we need more facts, we don't understand. How does the PA fit into this? We need more facts, we don't understand. How does the PA fit into this fraudulent scheme? Again, we need more facts. We don't understand. How does the PA connect to this? There is no proof that she even knew of this scheme, let alone that she participated in it or knew it was illegal. Show us. 5 times the state is unable to show. And so when Captain Khalid says in the Constitutional Court affidavit that the reason Ms. Cholota was charged with money laundering, corruption, and fraud is because she would not implicate Ace Makashule, we have to believe. We have to believe him, because that is indeed the truth. But because this is a constitutional democracy, that is impermissible. You cannot charge a person because they refuse to incriminate the person that you're investigating. It is your job, it is the state's job to investigate. It is not the state's job to do a half-baked job at investigating criminality and then wanting witnesses to come in and incriminate those people. That is not how it works. There has to be a case that is built by the state. Otherwise, the entire machinery of the administration of justice falls apart. And that's what the Constitutional Court is asking us to show them. Is asking this court to see that if the conduct would be an affront to the administration of justice, it cannot be allowed. And so we invite the state to look at all 4 of the grounds and issues, and for the first time, address them directly and show in what way the evidence that we have via their own witnesses does not prove that they lied to U.S. officials in this extradition. Those are my submissions, my lord.
Thank you, Mr. Capella. Mr. Pearson, we've been busy for a while now.
Indeed, so almost 2 hours, my lord.
Yes, and can we take a break for half an hour until 12:15?
As a court pleases, my lord.
Short and
All rise. Thank you, my Lord. As already previously alluded to by my learned colleague for the State does not endeavour to be too long, as we have already addressed at full length with regarding to the state of matters as to what the determination is to be made of by the Honourable Court. State has already filed 2 separate sets of heads of arguments, just with relating to the trial within a trial proceedings, as well in those of for today's proceedings. And State, as indicated in our heads of arguments as to paragraph 3, read the same to be read and supplemented to these heads of arguments. My Lord, with all due respect, if we were to go into each and every aspect as contained in the previous heads of arguments, I would be giving the court rather a textbook of information than a brief heads and summation of what we are before court today. My Lord, it is pertinently clear as per what the finding was in terms of paragraph 106 as well as order number 4 of the Constitutional Court. The matter was remitted back to this court to hear the 4 remaining grounds. The court then further invited us, both parties, further to make further submissions, as well as to provide heads of arguments, drawing now into the fact also as to whether or not this would bring about disrepute to the administration of justice. Looking at that, with all due respect to my learned colleague, the State has in fact already spoken at length to those 4 grounds. However, taking it further, we have to look at the initial heads of argument submitted by my learned colleague, Mr. Denason, with regards to the allegation that the State lied, misrepresented to the United States, that the accused forms part of a syndicate. My Lord, this has already been addressed at length in these heads of arguments relating to paragraphs 10, paragraphs 26, 28, and 29. However, furthermore than that, if we look at the indictment itself, my learned colleague makes much of the lack of the word syndicate. However, if we do turn to the indictment itself, it clearly explains the provisions of common purpose and working together. This is also to be taken to the point that my learned colleague raises with regards to the questions posed to the National Prosecuting Authority by the US counterparts with regards to the extradition. It is also correct that my learned colleague says that this is not something she's versed in. She's not versed in extraditions. We are dealing with 2 separate legal foundings. We're dealing with South Africa and the United States of America. Therefore, their understanding of certain concepts, such as common purpose, are different to what we have as common knowledge and common, as that is what we do on a daily basis. There is nothing wrong with the communications between the United States and the South African counterparts with regards to clarifying certain of these issues. The aspect had been as to whether or not, as raised by my learned colleague, with regards to the disputes where the initial letter had been drafted to the National Prosecuting Authority of South Africa with regards to clarification of probable cause, whereupon my learned colleague made much of the report of the forensic investigators, my apologies, which is also interesting to bring before the court, as this particular document, in its entirety, showing the links, was in fact handed and submitted to the court by my learned colleague for accused number 17. Therefore, it is before the court. But State does not want to delve on that because that is not what we are here before today. We are not here to delve deeply into the merits, despite how badly State at this juncture would like the matter to proceed. The South African citizens, the interests of the greater public, would like this matter to proceed despite all these preliminary issues. These aspects are detailed in clear with regards to paragraph 10.2 of our indictment with regards to the versions of common purpose. However, my Lord, I would be incorrect if we do not draw the court's attention to the debacle as to the other African country being Kenya, where my learned colleague fails to mention the fact that the Nigerian connections came about by virtue of accused number 17's own versions. It has been explained by the witnesses at length with regards to their initial understanding when they had drawn the movement record system and found the connecting flights. However, that point is in effect mute because it is confirmed that accused number 17 does have direct relations with another African country, where she herself has confirmed that she has a child in Nigeria. We cannot move away from that. What is also of grave importance for this court to take note of is that there had been an undertaking on behalf of Moroadi Cholota that she would be returning to the country. This was found and confirmed in the court proceedings of the brother of this very court, here for AJ, where it was also spoken with regards to, on the 23rd of, my apologies, on the 20th of January 2023, it was confirmed that Ms. Cholota would return, accused number 17. Up until the point of the 3rd of May 2023, there had been nothing. There had been an undertaking by the accused to return. By May, nothing. At that stage, it was well known, not at the time of the interview that took place, that the accused person was to become an accused. What is very important to note, as my learned colleague touches on it to a great degree, about the differences as to when the accused number 17 was a witness, and then it changed to she had then been charged on the 23rd of September. It was pertinently made clear that this was not the case. She had at that stage not been charged. She was only charged after she had actually been arrested and detained. However, what we can also not ignore is if we actually look to the documentation that had been submitted to the court in terms of the exhibits. Now, we have to be very careful to understand that the trial within a trial is not merely based on what had been testified to by Major General Gerber nor Captain Collins. There's a plethora of documentation under Exhibit 9 that had also been supplemented by my learned colleagues. This includes what had actually transpired during the extradition hearing in the United States of America. We cannot shy away from that. If we look at those particular incidents that occurred in America, we confirm, first of all, that it had not been ever brought into disrepute what the actual certification of the hearing of extradition was. The fact that Ms. Cholota, my apologies, Your Worship, if I may just find the relevant paragraph of the court. Had also consented to detention. Much ado is made of the fact that accused number 17 had been held in detention for 4 months. However, at the opportunity time when she was able to bring an application to be released, even in the United States of America, it was not done so. We cry foul now in South Africa when we had the opportunity to address those particular issues in the United States of America. Now, the court must also take note of the fact that even in America, she was represented. There were American counterparts representing her. However, it is clear that there was also a South African contingent assisting her with regards to her efforts of what to do. We have not only did she consent to the detention itself, but when it came to the hearing and the confirmation of the actual detention of the certification hearing, where we have that accused number 17, in fact, even confirmed the documents. She did not contest the documents that were submitted in the United States of America. That being also the FTI report that my learned colleagues make so much ado of now. This had already been present. We then have, ultimately, that accused number 17 was brought before our courts in South Africa, where the further preliminary issues arose. The further preliminary proceedings were brought about on behalf of accused number 17. My Lord, I would do this court a disservice if I did not draw the court's attention to the same with regards to the brother of this particular court. Because ultimately, we need to make a finding on grounds that have been adjudicated on, not taken on appeal, despite an undertaking that they were going to be undertaken, that an appeal process was going to be undertaken. The state preparing for this appeal process to take place. Yet, now we have, again, bites at this particular cherry in an attempt to have a second look at what has been decided of a brother to this honourable court by here for AJ. This is, in particular, if we look at the warning statement, and I've turned the court's attention to paragraph 108, where it had been put to great lengths about, as this is an aspect that is brought to light very often by my learned colleagues, Your Worship. It is one of the, my Lord, my apologies. This is one aspect that we do need to draw to the court's attention, that we can also put this aspect to bed for finality. It was clear, even starting, that accused number 17 at that time, during the time of the interview, after upon having requested and now decided for legal representation, we have to be alive to the fact that even the day before, accused number 17 was reminded and advised that legal representation. What happened that is not disputed on the 23rd, the very next day? It was inquired from her, did you follow up with regards to legal representation? And she had not. Only thereafter, the interview process further took place. It is also common cause, it is not disputed, that accused number 17 ultimately did in fact sign the warning statement, confirming that the contents thereof were correct. Now, we are not intending to use the warning statement at all with regards to trial purposes, because there is nothing contained in the warning statement. All that there was is that it was, as indicated in paragraph 106, in reply, that being the state, the applicant states that it was during the taking of the warning statement, my apologies, accused number 17, that I indicated I wished to consult with a lawyer. Only at that point. Only whilst the process had already been ongoing. However, no statement was ever actually formally taken from the applicant, because it is read in conjunction with the actual document. There was no statement attached. If we look carefully, it does indicate that the suspect was not willing to answer any questions at this stage and will provide her statement as agreed upon. Much was questioned of our witnesses at this stage as well, that up until this point, despite yet another undertaking by accused number 17, the same has not come to light. However, what is of very importance to note is paragraph 108, where the applicant, it was found by the brother of this honourable court, the applicant does not dispute the correctness of this document. Taken all these factors into account, it cannot be held that the applicant's constitutional rights have been infringed by not allowing her legal representation. With all due respect, my Lord, this issue is moot. It has been put to bed. It has already been decided on by the brother of this court. Furthermore, in the particular court sitting before here for AJ, much ado was also made with regards to the proceedings of the 22nd and 23rd of September as to how they took place. it was clear, to paraphrase, at paragraph 121, it was found that during the course of the interview, it became apparent to the officials that the applicant became less cooperative. This coincides with what was ultimately handed in inadvertently on behalf of my learned colleague and the accused with regards to Exhibit 11 being the transcribed records. Now, we have to pause here with regards to whether or not the recording device of the state was working. That point is immaterial. Gratefully, thank you to accused number 17, who ultimately, it was found, made the recordings herself. Had the foresight to actually record this terrified individual that my learned colleague would like us to believe. However, we leave that there. Further, the brother of this honourable court found, in terms of paragraph 122, where the applicant, now this is with regards to the warnings of legal right, that according to the argument on behalf of the applicant, these warnings amount to conduct which is inconsistent with the Constitution. The brother of the court found, I cannot agree with this contention. If during an interview by law enforcement officials of a potential witness for the state, it becomes apparent that such witness is not cooperating by questioning the relevance of certain questions, which is clear from Exhibit 11, and not answering in a satisfactory way, such officials should warn such witness of the consequences thereof. This is even more so when it appears to such officials that such witness may also be guilty of the offences which form the subject of such interview. My Lord, it is clear, it has been the state's submission from the very onset that at the point there had already been evidence that had been linking accused number 17 to the crimes and offences for which we are before the court. However, she had indicated, as per my learned colleague's testimony before the court, that she was happy to help. She was happy to help the country. Yet when questioned to obtain the actual evidence that would help the country, mum became the word. And the assistance was no longer provided. It is clear, without having to go into detail, how the proceedings happened, that accused number 17, indeed so, was met at her home by officials. She drove in her own vehicle, having an electronic device with her at that particular time, where she could also have sought legal representation, should she have wanted. The interview then started, where even during the interview, it was brought to a halt that accused number 17 could be accommodated to see her boyfriend. This is also not disputed by my learned colleague or accused number 17. Upon expiring of time that accused number 17, not the state, accused number 17 needed to attend classes and lectures, she left. Not being followed, not being abducted, and certainly not putting in the boot of a vehicle. She left of her own free volition and came back the next day. However, it has even been made pertinently clear in our previous heads of arguments, even the joviality by accused number 17, making such jokes as to say, is that all I'm going to get? If you want to see who was making light of the situation, my Lord, with all due respect, perhaps we should look to accused number 17's conduct at the time. However, my Lord, what is even more worrying than it all is that at paragraph 126 by the brother of this honourable court here for AJ, taking all factors into consideration. Now we must bear in mind the fact that detailed application papers were filed by my learned colleague, which included these grounds. These very grounds which we are again before court on. Where paragraph 126 it was found, taking all these facts into consideration, it cannot be held that the applicant's rights in terms of section 12, 1E of the Constitution, nor any other constitutional right has been infringed. What we have now is a court of equal status, albeit not in seniority, already having made a finding. What have we not done? What has not happened? Those issues, should they have not been happy with them, were not taken on appeal, despite promises of the same. What is happening today before this honourable court, and what has been happening before this honourable court? This honourable court is being called upon to decide on issues which has already been decided on. The principle of Ibrahim with regards to the extradition itself has also been put to bed with regards to the Constitutional Court, where the Constitutional Court had found, albeit with regards to how the extradition had been, if we read it in context, it was how it was ultimately brought to the United States' attention, that it was done by the National Prosecuting Authority and not the executive. It had been found that the state had acted with bona fides.
Did what?
Acted with bona fides, not mala fides. We have that finding on the one hand. Now, we have further findings, as indicated, that it has already been found that there's very issues to be addressed upon, have been adjudicated on, have been found that there is no constitutional infringement. We have already found that despite the extradition papers, the actual process not having been submitted as per Schultz, that is still no moment for this matter to not be heard by this honourable court. With due respect to the court before we are today, this is also not, as of yet, deciding on the merits of the case. We are yet to get there. We are wanting to get there, but we are being preempted from getting there, as had been indicated even in the previous preliminary inquiries or hearings of this court, where my senior counsel, Advocate Kasim, had even indicated how, with all due respect, it appears to them that the defence is relying on Stalingrad tactics to try and prevent the actual matter from being heard. How much more so than when we are aware of the fact that a matter has been adjudicated on, but yet we are back here again today. As indicated, my Lord, how the recordings of the day in question came to being, the fact that the state's machinery did not work, are immaterial. It's also despite how these allegedly had come to light with regards to the versions that had been put as to where these transcribed records had come from. It had been already made a decision by the court that that was pertinently false, and it was ultimately accused 17 that had made the recordings. It is also clear that that is not disputed. However, if we do look at certain aspects, despite the fact that state need not go into them due to the fact findings already have been made, there are certain aspects that we do not need to draw the court's attention to, specifically with regards to when we look at the version of the Section 204 witness and how it came about. This is not the juncture for, with all due respect to the court and my learned colleagues, a criminal procedure lesson. The court only becomes involved in admonishing a 204 witness when that witness is before court. It is not a process that happens prior. It was indicated very clearly by Major General Gerber with regards to Annex Exhibit 11, my apologies. We are on page 4, line 8, where it indicates we will obviously then, but at this stage, there's no reason for us to warn you in terms of the judge's rules or etc. But if you do incriminate yourself, we will stop you. And we will give you proper warning in terms of that. And then we will discuss the matter forward with you. Because there is 3 options. We can either, if you do implicate yourself, I do not know if you know what a 204 witness is, no. Whereupon accused number 17 then requested a 204. Therefore, it is clear as day that should accused number 17 had actually come to light with anything that were to implicate yourself, it was going to come to a stop. This was never disputed. It is indicative of the fact that should accused number 17 have come to light, the formal proceedings of the warnings of how the process of Section 204 would have taken place, and only at the time when appearing in the front of the court, this honourable court, or whoever at that stage might have been presiding over the trial matter, would then have admonished accused number 7, or there she would no longer be accused number 17, there she would be Ms. Cholota, to appear and indicate that if you do not actually divulge the true state of effects, that immunity that is given you would not be there. That is what a Section 204 witness is. It's ultimately to protect the interests of an otherwise would-be accused person. What is worrying is that, yes, it is true. My learned colleague is correct that there are a variety of concessions that she would also have made, that it was not necessary for her to come and testify on certain aspects, because there are certain aspects which are in agreement with the version of the state. That is true. However, the versions advance as to why we are again before court determining on issues that have already been adjudicated on were, for instance, the mental torture, the abduction. That there is no evidence before this court as to what accused number 17 would have said. My learned colleague for the accused does put forward what she might have said. That is of absolute no minute before this court. My Lord, even on this point, if we look at the mental torture, it was indicated that she had confirmed she was unwashed. It was then taken back to the days of what hygiene in terms of our old era might have been, where it was even put forward by my learned colleague, unwashed, day after day after day, were her exact words before this court. Here we have a mere few hours, and she still went to class and came back again the next day of a free violation. We are talking about a number of hours, not days, not locked in a room, not having all electronic devices taken away from her, not being allowed to meet with an individual from the outside that came to see her. Having been warned that if you implicate yourself, we will stop you and we will assist you. Having been constantly reminded about being able to approach legal representation. But my Lord, let me take you back. This has already been decided upon by the brother to this honourable court. My Lord, ultimately, if we look at the facts beforehand, we have an individual, accused number 17, that was extradited to South Africa. The bone of contention had initially been these grounds, which have already been dismissed, ultimately, because they've already been decided on. During the addresses and the heads of arguments, aspects then arose with regards to Schultz, which the Constitutional Court had already made a finding on, to say that that is not the juncture for this to happen. The juncture for that to happen would have been for, if you had wanted to bring it in, for those very specified plea grounds to have been amended. This was not done. Again, we are now broadening the issues to try and incorporate further constitutional issues. However, that is irrelevant. Yet again, I repeat the same to the Honourable Court. It has been decided on. Without the accused number 17 coming to testify, obviously, the only version before court is that of what is before court in terms of all the exhibits, as per Exhibit File 9, as well as Exhibit 11, and further on exhibits that confirm, most importantly, Exhibit 9, File Tab T, which is the FDI report, which shows the direct link, which ultimately confirmed, once submitted, that probable cause had been found. I beg the court to not forget that in any event, when all this documentation had been presented to the very court that was making the decision as to whether to extradite or not, to the very court where initially accused number 17 had requested an extension so that certain aspects could be dealt with, certain applications could be filed in South Africa with regards to the hidden, alleged political agenda against her. This, too, was never done. Ultimately, my lord, all this was allegedly to move the accused in a form of coercion. To coerce her to do what? To say nothing and to not appear in court. My lord, if accused number 17 truly does want to help her country, now would be the time that she confirms that these grounds have been decided on, and she confirms that this matter, the only way for this matter to be completely dealt with, is as per our prayers. That this matter finally be put to bed again, if one can finally do something again. And furthermore, indicate that this matter, the only way for this matter to be delved into, because now, if we look at probable cause was sufficient, we go further than that. State submits to the court that there was a prima facie case. That is why she is here before court. However, all that was required was probable cause. It was found to be there. Those were the only basis. It was not brought into disrepute with regards to the actual FTI report, barring to say as to when it had been submitted. The actual report itself, as submitted by the defense, was not contested. That information is what is only to be able to be left before this honourable court, in fact, in terms of the trial, that the merits of the matter can be dealt with. It is respectfully submitted to the court, my lord, that taking into consideration our current heads, our current address, our previous heads, as well as the previous address, that the findings of the previous courts as well have spoken to the fact that the onus has been discharged with. That it is through the uncontested evidence that probable cause, bona fide misrepresentations, if there had been any, and the absence of any abuse of processes, that this court does in fact therefore have jurisdiction. It is also a sad day when we look at what the true sufferers had gone through, if we are wanting to liken, for instance, Ibrahim in this matter. That he did not just willingly come with the state, he was abducted. If we look at torture, even as per my learned colleague in terms of a heads of argument, that quotes from Baklas, where the end game, that if they did not get what they wanted, killings would follow. My lord, if that is not a gross exaggeration of the facts beforehand, I do not know what is. A person that was free to come and go ultimately as they pleased, to be likened to somebody that was truly tortured and at times murdered. That is a travesty of justice, to liken this to incidences such as that. State would furthermore submit to the Honourable Court that if the prosecution against accused 17 were to be halted at this ground by indicating that we do not have jurisdiction, that would itself bring about the administration of justice into disrepute. Because that would allow serious crimes of public interest to go unadjudicated. Individuals where there are strong links to those particular crimes to go unadjudicated on. State therefore respectfully submits that this court clearly does have jurisdiction to the matter, to hear the matter, my apologies, and that ultimately that this matter now once and for all be moved forward, that we can adjudicate the matter on the merits before court, as the court pleases.
Thank you, Ms. McPherson. Ms. Makapela, I do not know whether you want to reply. It is now 10 minutes to 1. If you do want to reply, do you think you will be able to do that in 10 minutes' time? I'm not trying to place any limitations on you. If you say it's going to be longer than 10 minutes, then we know that we will have to adjourn for lunch sometime and then come back in the afternoon. Can you just give me an indication what you think?
My Lord, it would not take 10 minutes. It
Okay.
will definitely take longer. But my suggestion would have been, is it not possible to go over and rather finish earlier than to break for an hour? But if we must break, then
Yes, I'm quite amenable to that suggestion. So if you want to proceed now, I just want to find out from the court staff if there's any objections. I have to look after them, and
Yes.
it's their lunchtime at 1 o'clock.
yes.
I see thumbs up, so you may proceed.
Thank you, Ms. Rihanna. My Lord, if I could please start at the very judgment that appears to now be the basis for the state's argument, which is the judgment of Yefer J. That is at volume 5. Volume 5. And I'd like to start from paragraph 164. And this is the same judgment that Mr. Pearson has been referring to. And I've been quite confused by the paragraphs that she's been reading from, because from paragraph 164 until almost the very end, Judge Yefer makes clear that it is this court, the trial court, that can determine by looking into the evidence a 106 claim, and that the plea, the special plea, and the grounds that we had brought before him by way of a constitutional damages claim are best dealt with by this court. So to hear, and also it was the state's version that we were premature in bringing that matter before Yefer. In fact, in the state's papers in this matter, the suggestion was that these are issues that will be best dealt with by way of a 106 claim before the trial court. The 106 plea that Judge Yefer found on was from the state. It was him agreeing with the state. So to say that these matters have been put to bed and that this has already been decided, that is, it's confusing. Because if we look at paragraph 164, and I'll read paragraph 164, 165, 166, as well as the final one in which he finds that these are matters best dealt with by this court. At 164, it can be taken as a fact that the information provided by the state had been incorrect. That's what this court says, per Yefer J. More importantly, upon the most cursory reading of the judgment of the magistrate, Judge E. Aslan, that is the U.S. court judge, presiding over the extradition hearing, it is clear that the entire basis for the extradition proceedings was information the state had provided on the applicant. The U.S. did not conduct its own separate investigation or confirmation of the facts. It relied solely on the accuracy and veracity of the information given to it by the state. Paragraph 165. It is patently clear that the state is therefore to blame for putting this incorrect information before court during extradition proceedings. The state should have made certain of its facts. I agree with the submissions by Mr. Makapela to the effect that the state would provide false and incorrect information to authorities of another country concerning a South African citizen presents serious public interest concerns and has serious implications on the interests of justice. I also agree with his submission that the above conduct by the state grossly infringes on international and constitutional law. It's quite clear what the court found. The court found indeed they put false information before U.S. authorities, and the U.S. did not conduct a separate glancing at those facts, and that is contrary to constitutional law and international law. That is our version. That is our version, and this judgment confirms that. And then, in relation to 106, at paragraph 173, the court states that brings me to the conclusion as far as this point is concerned. In terms of section 106 of the Criminal Procedure Act 51 of 1977, when an accused pleads to a charge, he or she may, inter alia, plead that the court has no jurisdiction to try the offense. That is to be dealt with by the judge presiding at the criminal trial. In this regard, I refer to authorities dealing with discouraging preliminary litigation prior to criminal trials, and in particular the dictum of Naidu J in the matter of Mukhesi and others versus the state, which is why he dismissed our application, and which is why he found that those issues were best dealt with by this court, because then evidence, oral documentary testimony would be laid before this court, which was not before him. So for the state to advance this position that they now advance, which is that none of these constitutional issues and constitutional infringements, I think the word was, they're immaterial, because the brother has already dealt with, that's a misreading of this judgment. That judgment says this court is best placed to make these determinations, but on what was before that court and what he could see, the state very much placed incorrect information before U.S. authorities and should have made certain of their facts, and that they didn't was a gross, and he uses the word gross, violation of constitutional law and international law. So hopefully there aren't any misinterpretations of that judgment. It's fairly clear on what it states. And then the Constitutional Court in the recent judgment clarified the issue of the U.S. court and the South African court. The court per Theron was clear that what Ms. Cholota is complaining about is the conduct of South African functionaries. And so that is permissible. That's what the Constitutional Court said recently. So I wonder if my learned colleague even read and understood the judgment of the Constitutional Court, because that's what it clearly says. And so to be talking about, but she should have tried to challenge this in the U.S. and she didn't. Those were the submissions of the senior counsel before the Constitutional Court, and the Constitutional Court found no. She's well within her rights to do that now, because it's the conduct of South African authorities. It would have been ludicrous for her to challenge the conduct of South African authorities in the U.S. And so, again, but my lord, this unfortunately happened the last time, where there are clear issues before this court. There's clear versions that are being placed by the defense for Ms. Cholota, and the state chooses to miss the point entirely. And at this point, it feels like it's almost intentional. And much is made about nothing but the actual issues that we need to be doing, or that we need to be determining, are not. We asked, in my main submissions, I asked that the state address its witnesses' testimonies in relation to the four issues. Instead, you hear about the judgment of J. As much as it is instructive, in terms of the evidence before this trial, within a trial, it is the oral testimony of the witnesses and the documentary evidence that is paramount. None of that was done. We heard much ado about, I tried to really record what the submissions were, but I really struggled. But the main thing is that, again, we have a situation where the main issues are not dealt with. And then what's going to happen? We're going to go away. Then there's going to be an application. And then in the application, this court is going to be accused of, you didn't allow us to say this, you didn't allow. Yet they are the ones that are supposed to say everything that they need to say. And so, again, my lord, the Constitutional Court, in remitting this matter, which is why I asked whether or not they have truly considered the judgment, in remitting the matter back, stated that the four grounds are to be determined, and it is to be determined if they are confirmed to be true. Is that sufficient to say that it would run counter to the administration of justice, and it would be an affront to the public consciousness for this court to state that it has jurisdiction over accused number 17? None of that has been addressed. In what way have their functionaries and their conduct, in what way can it not be said that that conduct is constitutional? How is it constitutional? That's what they were supposed to show this court, that what we did was constitutional. They run away from that at every turn. But to what end? And then there is the quite comical suggestion that we are doing a Stalingrad, when it was the state that appealed the first time on 11 June. Then it was the state again that petitioned the Supreme Court of Appeal, and then it was the state again that petitioned the Constitutional Court. And then they claim that they want to sit with No, they don't make the necessary points that they're supposed to make, and then they want to run to the next court to claim that the previous court. And this is consistent conduct. They did that with the magistrate. When the magistrate said, I gave them an opportunity to state why it was that she did not apply for bail, and they did not take that. Then before Yefarje, they say, no, we weren't given an opportunity. That sounds very familiar, because that's exactly what they said to the Constitutional Court about this court, that we weren't given an opportunity, when in fact they were. And in fact, they were taken to the DPP's document that says, Aina Villa Somaru, on behalf of the government of South Africa. That was Audi. But seemingly, they seem to understand it differently. And so, again, all of this that we've just heard does not prove at all that the witnesses of the state proved beyond reasonable doubt that the extradition was lawful. They confirm that that is what they did to Ms. Cholota. They confirm that that is why they charged her. And if we take the cumulative meaning of their testimony, and my learned colleague is correct when she says that it is only the things that are before this court. I think, what did she say? She said the only version is that is before this court. Indeed, our entire heads of argument are based on the evidence of the witnesses and the documentary evidence. And on that basis, the four grounds are proven to be present. But over and above that, the conduct of the two officials, perhaps in concert with the senior prosecutor, but the conduct is unconstitutional. It is unlawful. And so what Ms. McPherson ought to have done is to show this court in what way is this conduct constitutional. In what way? We are yet to understand how such conduct can be said to be constitutional and how such conduct can be said to be lawful. And so the gist of the reply is that Yefarje actually stated that the information they put before the court in the US was incorrect. Yefarje states that the state ought to have made sure of the facts. Yefarje states that they didn't is a gross violation of constitutional law, and it is a gross violation of international law. Now, I think the only point that I understood is the Kenya argument. They state that, yes, but she herself admits that she had connections in Nigeria. Once again, an almost intentional missing of the point that is being made. The point is, the state told US officials she was a flight risk with connections in Kenya. They did not say in other African countries. They did not say we stand to be corrected. They did not say that this comes from the movement forms. They stated what they stated. And they keep trying to bypass that by saying, well, it wasn't that far-fetched because indeed she has a son in Nigeria. Then that is what should have been in the finding in the affidavit. Then that's what should have, and that would have been accurate at the very least, because she does have a son in Nigeria. And the state knew that. And so, again, my lord, it's this. There was a statement that, with regard to the hygiene thing, my learned colleague stated that she was subjected to that lack of hygiene day after day after day. That is not what I said. Which again, it drives the point home. Are we even being heard in these submissions? Are our submissions being read? Are judgments actually being read and understood for what they are? Because I stated that previously hygiene was used as a torture tactic. And one of the ways they would do that is to have the victim, not Ms. Cholota, have the victim sit unwashed day after day. And that the similarity is that they did that with her for that day in the interview. And then there's the constant mention of those that are truly tortured. Those that are truly tortured. The ones, it's an insult to the people who are truly tortured. Taking it back to the fact that we have these statements from state officials. We have these statements from the state. that there is such a lack of recognition of the incorrectness and unconstitutionality of their conduct that they would regard that what has happened to Ms. Cholota does not equal any type of torture, let alone someone who has been truly tortured. That is embarrassing, and that is unfortunate. But that is not our client, but it's very unfortunate to have that be said, because mental torture, indirect torture, there are so many forms of torture, and the police know this. The police know this. The police know this. These methods form part of case law and cases all around the country all the time. These insidious methods of torture are well known. They're not a secret. And so to want to define some torture as less than other torture because, well, this is true torture, to even use that statement, my lord. But for purposes of the reply, there's nothing that I heard and there's nothing that I read in the heads of argument wherein the state, beyond reasonable doubt, has shown that those 4 grounds are false and that it would be in the interest of justice and the administration of justice for those grounds, if they were to be found to be true, to be ignored. And I'm not sure in this instance, because they've done it so many times, I'm just not sure it's a bona fide error anymore. We cannot attribute everything to a bona fide error. They purposefully didn't sidestep this conversation and this issue. But I say that so that it is on record that that is in fact what they've done. Beyond that, my lord, I think in closing, to reiterate the relief that we seek in this trial within a trial and this remitted trial within a trial, that appears at the very end of our heads of argument. And for the sake of completedness, we request this court to grant relief that the extradition of Ms. Cholota from the United States to the Republic of South Africa is unlawful. That's at the bottom of page 28 of our heads. And then the second is that the conduct of the state in the extradition of Ms. Cholota was irregular, unlawful, and unconstitutional. And that the conduct of the state in Ms. Cholota's extradition further amounts to an abuse of process and serious deviation from constitutionally enshrined rights, which would bring the administration of justice into disrepute, and as such that the South African court does not have jurisdiction to try the offenses that she is charged with. In summation, we do not believe that anything that has been put forward by the state shows that this was not an abuse of process, shows that this was not a serious deviation from constitutionally enshrined rights. If anything, they further reinforce that their conduct in this matter really truly brings the administration of justice to disrepute.
Thank you, Ms. Makapela. As I've indicated on the previous occasion, after hearing these closing arguments from the respective parties, the court intends to hand down its judgment in the trial within a trial as instructed by the Constitutional Court on 18 February at 9:30 in the morning. Thank you. The court will now adjourn.
All rise.